So I'm Carol Strickman, and I'm a senior staff attorney at LSPC, and am one of the attorneys on the Ashker versus Governor solitary confinement litigation. And we pulled this, okay. And after people got out of SHU, we were seeing that they weren't getting paroled. A group of us came together to create a committee to try to work on this, and one of the things we've done is create this presentation and a previous webinar for attorneys and others. And so I'll be your moderator today, as well as make a brief presentation myself. So anyway, and I'm just going to ask each of you to introduce yourselves briefly, and then we'll start with the program.
Okay, I'm Keith Wattley from Uncommon Law.
Hi, I'm Johnny Murillo, a Soros Justice Fellow at the Opportunity Institute.
And I'm Terry Kupers, a psychiatrist.
Okay, thank you. So I'm just going to start by just giving a little background. Many of you may already know this, but just a big picture background, historical background of what we're dealing with, and we're dealing with basically the situation of gang designation by the Department of Corrections here in California. And apparently that started around, at least by 1979, if not earlier. And at that time they had identified 7 prison gangs that they thought were problematic for the institution. And it was a very informal manner in which they would label someone. A person wouldn't know they were identified as being a member of a gang at that time. Over time, the process became a little more formal, and then it wasn't until I think around 1985 that they started just putting people into the SHU, Security Housing Unit, solitary confinement, simply because of gang membership or affiliation. And this was an administrative term. It means that they hadn't committed a rules violation. It was just because of the label that they were, and what the threat that they read into that they would put people in SHU. And it was for indefinite. And you could get out, though, if you were willing to debrief, meaning admit your membership in what you did and start naming names about other people and what they did. Eventually, the labeling of this gang validation became more formal. You had to have 3 source items, 3 pieces of evidence, but there was really no meaningful standard of that, and there was very limited disclosure to the prisoner of what it was they were relying on. The designation would be approved in Sacramento. Later they expanded it to include associates. So they had members and associates. In 1999, the prison system created an alternative to debriefing of sorts, which was called the inactive review. Every 6 years that you were in SHU, they would look at whether they look back the last 6 years to see if you did anything that they considered was active participation in a gang. And if there wasn't, then you were considered inactive and you would be released from SHU. Well, all they needed was one thing that you did. It could have been 5 years ago, and it could have been as simple as signing a birthday card for someone else who was in the same gang, allegedly, that you're in. So the level of, it could have been much more than that, but it could have been as minimal as that. And keep in mind that you would get 5 years for murder, but now you're getting like another 6 years for signing a birthday card. So it was really a very outrageous system, and there were lawsuits. There was a Castillo case, which did impose somewhat higher standards for the evidence, but it didn't seem to be fully implemented, or it ultimately was ignored in certain ways. So over time, these SHUs were getting filled up. And we have 4 prisons that have SHUs in California: Pelican Bay, Corcoran, Tehachapi, and New Folsom outside Sacramento. And
Carol, and the women.
And then that's true. Then there were a women's SHU in CIW, right?
I think it's
It was at Valley State.
It was at Valley.
Now it's at CIW.
Okay, and most of, the women have not been too impacted by everything I'm saying. And when we got our victory in our case, the CDCR seemed to almost take the position that it didn't really even apply to women, or they didn't have to, but they had actually been releasing women, and it can certainly, but it does. This has primarily been a men's issue. Let's see. So the SHUs were filling up, and there were thousands of people in the SHU, and then also at the same time, people who would debrief would end up going into what they called sensitive needs yards, SNY yards, which would be in other prisons, maybe some of those prisons, but other prisons throughout the state. And as I understand it now, these sensitive needs yards are just like half a substantial part of the prison system is now these sensitive needs yards. CDCR is saying that this is not working or something. But anyway, so that's what was going on when the hunger strikes started in 2011. And there had been a hunger strike at Pelican Bay in 2001, but it hadn't lasted too long. There was some legislative interest, but not too much really happened as a result of that. But in 2011, does everybody remember the 2011 hunger strikes? Yes, we got some, yeah. So there were two. The first one was about 3,000 people. The second was about 6,000 people at its height. And I think, and then what happened as a result of that was the prison had agreed that they would revise their regulations, and they did do that. They in 2012 they moved them in a direction that was good in certain ways, and not in a good direction in other ways. But they did decide at that point that just that association. They created two different levels of gangs, prison gangs. They called the original 7 STG, Security Threat Group 1. They called another group, which could be endlessly long, STG 2. And there were different rules about going to the SHU. Only members in an STG 1 would go to the SHU automatically. Otherwise, they needed to see some sort of behavior. Well, but while those rules were being in the works, the prisoners who'd been involved with the hunger strikes did not trust CDCR to really, give enough relief, and did reach out to attorneys, and particularly the Center for Constitutional Rights, which is our lead counsel, did agree to file a case, and we did go ahead and do that in 2012. And we didn't file a brand new case. We took over a case that previous prisoners had themselves filed. So, and that case, our case settled in 2015, and the key elements were that you can't go to SHU for just association or membership, not for your status, but it has to be a behavior-based, a rules violation that's a SHUable offense, and that's how you get a fixed term in SHU. They can tack on if your rules violation was related to prison gang, and they prove that. They have to prove a nexus, is what it's called, connection. Then they can place you for 2 more years in SHU in what they call a step-down program, where you're supposed to be given opportunities for education and programming to, I think they like to think, to encourage you to move away from a gang, but also to have some legitimate programming for upon your release, and so that's when they made these new rules, they did case-by-case reviews, which they had done previously. The earlier case-by-case reviews under their new regs look back 4 years. Did you have a rules violation or a gang connection in the previous 4 years instead of the previous 6 years? And a lot of people did get out of the SHU during that interim period, the 2012 to 2015 period, about 1,100. And then with our settlement in 2015, about another 1,100 people got out. They looked back only 2 years, I think, and most people did get to some kind of general population. And this was really important because, well, first of all, let me just say the result of that was they ended up closing 2 of the SHUs, one in Tehachapi and New Folsom, and the other 2 bigger ones, Corcoran and Pelican Bay. They converted some of those beds to something other than a SHU bed. And so the SHU population has drastically reduced. So that's the really great news. But but a lot of things haven't changed, and one of them is that prisoners are still being validated. They're still using confidential information, you know, from debriefers or other sources, and we're seeing gang-validated prisoners going to ADSEG and SHU for other reasons. There's there's a lot of conspiracies being alleged, and still using confidential information. So there's a lot of problems that are going on, and but in terms of parole, which is what we're here today to talk about. Previously, we were seeing that it was pretty standard practice for the parole board not to parole prisoners in SHU, and they would say, well, you have to get to a yard where you can have programming. You know, they might not say you have to debrief, but the only way to get to a yard, you know, would be to debrief. So it was sort of coded language, and so that was. You know, one of the reasons and one of the things we discussed in our complaint in the case, the Ashker case, about the inability to get up to parole if you're a lifer, you know, who has to go up to the parole board to be released, as opposed to someone who has a fixed sentence who will get released. So, so now though, that these prisoners are in general population, was like, finally, now I have a chance to get released to the community. And what we've been seeing in the last period is people still not getting released. And I guess we know a couple who have been gang validated. Maybe you know more people, but we're trying to understand why that happened in their cases. But we're still seeing that same sort of coded language about get to a sensitive needs yard, or get to a yard where you can program. You have to meaningfully disassociate from the gang. I need to see on paper, I need to see a piece of paper that you're no longer involved with a gang if you haven't debriefed. We're also seeing that those people who participated in hunger strikes and got 115s, that's being used as ongoing, you know, misbehavior. And also the parole board points out that someone hasn't been on a general population yard long enough to demonstrate that they can get along with other people or something like that, or they don't have enough work experience or programming and those sorts of things. And so overall, it seemed to us that they're not really being treated fairly. Hence, our committee was formed, and later at the end you'll hear about some of the things we've been doing. But one of the things we've done is to try to look at this and figure out how we can help prisoners coming up for parole deal with these issues, and that's why we've developed this program today, bringing together people unlike myself who have experience with parole, such as Keith. So let's turn to Keith. So Keith, what can you tell us about how the parole commissioners look today at a gang-validated prisoner coming up for parole?
Well, the parole commissioners operate today, for the most part, the way they have been for quite a few years. Same kinds of questions, same kind of concerns. And in some ways, it's a mistake to think that this is a whole different process, because it's really not. And you haven't suggested that, but you have suggested that there are some ways that that we need to think differently about the parole board in light of people coming out of the SHU and going, and that is true. I've had a lot of experience dealing with the parole board with people who've been in the SHU, and certainly a lot of people who haven't been in the SHU. The bottom line, in my experience, is very, very, very hard to litigate your way through the parole board. We've done that. A lot of people have done that. But it's a whole lot harder to do now than it used to be, because the parole board has gotten a lot better at protecting their decisions against courts that might want to reverse it. So most of our success now comes the old-fashioned way. People do the work that they need to do, change their lives in the way that they need to, talk openly and honestly with the parole board in order to go home. It actually does work. And in fact, with the parole board, it's about the only thing that works, in my experience. There are kind of three groups of people that the parole board will not release. And they're kind of broad categories. First one is liars. People that they think are lying to them, they will not release. Lying about anything. It doesn't matter what you're lying about. If they think you're lying about any minor thing today, they will deny you parole for the most part. Also, strangers. People they don't know or understand or just can't identify with. If they can't get your story, they're going to deny you parole because they're going to make up one about you. If you're not giving it to them, they'll make up one that works for them and it usually won't work for you. And the third category is defendants. People who show up in a very defensive way. They take a posture, assume a posture that's well, very defensive, as if when they were originally charged with the crime, their attitude was, well, I'm not going to give them anything they don't already have. I'm not going to give them anything to use against me. I'm going to keep my answers really short and not help them do their job. Those people are denied parole all the time because the commissioners are mostly law enforcement folks in some capacity or another, and they've spent their careers locking those folks up. And so it's a very familiar dynamic for them. Okay, I'm going to try to get the information, they're not going to give it. My job is to lock this person up. They're pretty good at that. And so as soon as that's a familiar dynamic they feel, the hearing's pretty much over. So that's kind of the defendant's category. But coming back to the liar part, you have to be willing to and able to tell the truth about your family background, about drugs, alcohol, about gangs, before prison, in prison. And now gangs, even that is, it's a broad enough category. So if you're willing to talk about just the sort of the political structures within the prisons, that's plenty. You don't have to admit membership with any of sort of the 7 that Carol was talking about. But if you go along with the politics of it, follow the unwritten rules that keep you safe, keep you alive in prison for 20 or 30 years, you need to talk about that. Be willing to share that with them, your experience of that. And that also involves rule violation reports. If you got 115s, talk about them. Show a way to show that you're responsible for whatever it happened to be. That information, you're sharing that with them, starts to build your credibility, especially when you tell them things you don't have to. This is, again, as I said before, this is how you get the parole board to feel comfortable enough to grant you parole. It's not the same thing as litigating your way out of prison. It can be, but it is a different avenue a bit. But if you want to go through the parole board and have them feel that they can release you, they have to get to know you. They have to feel like you're telling them the truth. They have to feel like you've given them your story and it makes some sense. It doesn't have to be their story, but it has to be a true sounding version of your story. And again, you can't be defensive. You have to be really wide open about all those things. So that's one thing you have to do. Part of that truth is once you've identified factors from your past that contributed to decisions you made, whether it's joining a gang, whether it's getting involved in the drug trade, whatever it happens to be, you have to show them how you found the time, access the programs in prison that would help you address those factors. This is where most people who've been in the SHU are lacking because there's not much in the way of programming available to people housed in the SHU. And so for the parole board, in addition to the fact that they would rely on the Department of Corrections determination, this person's a validated gang member, therefore dangerous, so the parole board already has made that decision. But they're also saying, I know because he's been in the SHU, he hasn't accessed the programs, that part of my decision is done too. But you have to be able to show that you have taken advantage of whatever programming is available to figure yourself out, to address those issues that contributed to the decisions you made in the past. And then the last part that you really need to do is you need to show that you've developed a positive support system going forward, whether it's family, friends, other connections on the outside to show that you'll be released to a safe place and a supportive place. So that's what people going to the parole board have to do. Everybody has to do. And what their families need to do is, one of the toughest parts is they need to give their loved one permission to tell the truth. Because a lot of times, the clients I work with, they're holding on to things so they don't make mama look bad. So they don't talk about their alcoholic father. So they don't talk about the abuse in the family. And so they hold on to, no, this is my fault, I did this, I'm not going to put this on anybody else. Well, we're not asking you to put it on anybody. We're asking you to tell the truth about what was going on. Families can help tremendously in giving their loved ones permission to tell the truth. Some of that is permission that's also saying, we're not going to abandon you. We're not going to leave you alone. We're here with you. We admit you did this crime. We already know you did it, right? The family is sort of saying, we already know you did it. Let's let you off the hook so you don't have to feel bad. We already know it. Let's get past it. We're not going anywhere just because we know you did it. So being willing to tell the truth, families sharing that, but also that allows the families to start to explore what was going on. Why did we make some of these decisions we did? We did together, right? Or we all contributed to this in some way, some of the decisions and things that happened early on. So there's definitely a significant family component to the telling the truth part. That involves things since you've been in prison. If your family member has been, paying your cell phone bill for the last 10 years in prison, that's a problem. You got to deal with that. We all have to deal with that. Be honest about it. Let's get past it. I'm not doing that anymore. I'm not supporting that anymore because that's going to keep you in prison and away from home. That's a reality. But so telling the truth about what's been happening, what's happening now, and also families creating that support system. Be able to identify and then document through a letter. Here's where he'll be able to live when he comes home. Here's where he'll be able to continue with his 12-step meetings when he comes home. Here's the church he'll belong to. When he comes back to live with me, I'm his spouse, and we've identified a therapist who agreed to see us, every week or every month to help us in this transition. Like specific, concrete ways in which families are going to support their loved one when they come out. So they have to do all those things. Now, the big part in the middle that people from the SHU are missing is the programming part. It's both showing that there are programs they've participated in and showing the benefit to those programs. They're kind of two different pieces. I have to say that I had a client very recently who was validated, had been in the SHU, had just gotten out a year ago. Not a whole lot of time to be on the main line. Went to the parole board. He was granted parole. Never debriefed, and he had some status with the gang. Now, the reason he was granted parole is because he told the truth about all that. He described his role, described why it was something he got into, what he did, kind of actions he was involved in. And when the committee, this other part is kind of where the lawyering part comes in, is he talked about how he recognized how, wrong-headed that was, misguided that was, and that he decided to turn his life around. And he started to do that. He got out of the SHU because the settlement and the new rules. And when he got to the general population, he associated with different people doing different things. And the commissioner asked the question, well, if you made all these changes, why not debrief? I said, you can't ask him that. The commissioner said, well, it's a legitimate question, and I'm curious about that. I said, I understand you're curious about that, but you can't require him to debrief. I don't think you can ask him to debrief. I've directed him not to answer that question. And the commissioner kind of hemmed and hawed a little bit and was bent out of shape, but couldn't do anything about it. And they went on and talked about other things. Again, he was granted parole. Asking those questions, they may want to know, but he doesn't have to talk about it. Not everybody can sort of get away with that. But this particular person, the thing that made the biggest difference, that middle piece I keep coming back to about the programming, he started when he was in the SHU. He started correspondence courses, reading books, understanding himself before he got out of the SHU. So when he got to the general population, he was able to hit the ground running, get involved in some of the programs, and by the time he got to the parole board, a year out of the SHU, he was able to show he had an understanding of himself that really proved to the parole board that he'd done the work. And he started in the SHU again, but he hadn't started that long into the SHU. I mean, he'd probably done maybe 6 months or a year of correspondence courses and books before he got out of the SHU. And then the rest of that year, it was whatever was available in the general population setting. So you don't have to have that long a history, but if it's genuine, if the change you make is genuine, if your understanding of yourself is real, it scores a lot of points with the parole board. It took him away from being somebody who's a gang member they don't understand to somebody who's opening up to them and showing them who he really is. So it actually does work. The other thing that was a big difference in this case was the commissioners. Some of them they're all former law enforcement in some way. Some of them within the Department of Corrections. There's one who's a former gang lieutenant. He brags about it just about every hearing. He prides himself on knowing the gangs and better than anybody else. But some of these commissioners, well, most of them at this point, they're so far removed from actually being in the prisons, they don't actually know how they work very well. So I was able to explain to them what has changed. So when the client was explaining that, the commissioners were having a hard time saying, look, we know anybody who's been hooked up like that, been as involved as you say you were, can't just walk away. It doesn't work that way, right? That's like just the oldest understanding within the Department of Corrections. You can't just walk away. Not and still be on the main line, because this guy is not on the sensitive needs yard. This guy's in the main line. They said, well, you can't just walk away, so this is not credible. But what I explained to them was things have changed. That you can be on a lifer program in prison, in the general population, even if you used to associate with some of these structures, even if you did some of the dirtiest dirt they do. You can choose to be on a lifer program, and it doesn't get you killed. But it's a trade-off. You're saying, I'm no longer participating in that stuff. And they're saying, we got it. You want to go home, there's some programs, do what you got to do. But don't look to us for any kind of help, right? We're not going to protect you. You're not a part of this anymore. So you're completely on your own. That's the trade-off. If you're going to walk that path, walk only that path, and don't dabble in any of this other stuff. It's a kind of a mutual respect thing. Now, that's how yards are these days. They weren't like that a couple years ago. But the commissioner kind of understood, okay, that makes some sense. Things have shifted. The people who are on the prison yards, there's a different mix of people. There are different programs people are doing. But because I helped the commissioner understand something that they didn't know already, and because it made sense with what this particular client was explaining his own journey, they said this makes sense. And the last piece to that was, they said, in announcing their decision, they said, we found you suitable. There were like 10 pages of confidential information, 10 pages of a list of documents, so a lot more documents, right, of confidential information. But they said, we didn't use that because you told us all that stuff. The confidential stuff wasn't even helpful to them because he gave them everything they needed to hear. Showed them who he was, showed them how he changed and the support system he created. So that's what it takes to get through the parole board. And if folks are not busy doing that, they're not going to get through the parole board. Whatever else they may be involved in, if they're not doing those things, it's not going to happen. But if you do those things, it can happen. It takes a while. It can take a while. You got to access the right programs. If you're in a place, some people released from the SHU get stuck in a facility that doesn't have much in the way of programming. Still, even though they've expanded some programs, they're still not as available as they need to be. But start with correspondence courses. Start with books. Start that. People start that in the SHU, and it makes a huge difference. But wherever you are, do that. I know some of the materials over there have lists of books send them in. Have people start doing their work. But it can happen. I don't know what the numbers are yet. I haven't looked at them. I know what happens in individual cases, and I've handled a number of them, people from the SHU. But I know how the parole board operates, and if you find a way to show them who you are, it makes it so that you're not, they believe you, so you're not a liar. You're no longer a stranger to them, and you're not defensive. They don't parole defendants. They parole people who have sort of transformed that relationship to the truth, to themselves, to former lifestyles. Those are the people they grant parole to. So I think I'm going to be answering questions later, but that's all I want to say for now. You want to take questions now? Is that how we're going to do it?
Oh, I was going to ask you a few other topics. That was very helpful. One little thing just from that. When you said you were able to explain to the commissioners how it is now, is that something you did in writing in advance, or is that something you did in the hearing?
I did it in the hearing.
Okay.
Now, there are times when I've submitted things in advance to kind of help them understand what to anticipate in an upcoming hearing. Mm-hmm. And probably the next one of those cases, I might do that because it made a difference in this case. Mm-hmm. I could see them kind of, oh, I didn't realize that. Like that makes a lot of sense. Mm-hmm. You know, so I might that can be helpful to frame the case they're about to review. Some of them don't read the stuff anyway, yeah. That we submit ahead of time.
Okay. Would you say the approach that you're describing is the same or similar for the prisoner getting interviewed by the psychologist?
Yes. Yeah. I mean, it's in a lot of ways, the interview with the psychologist is the same as the meeting with the parole board. The difference is you usually have less time to explain yourself with the psychologist. They're filling out forms, they're checking boxes, scoring different answers, and not often giving you a lot of time to elaborate. So a lot of people feel rushed. They feel like there's not an opportunity to share everything there is to share about their story. Try it anyway, and it helps to bring as much in writing. So the example, if you write out a statement of your crime, for example, that you've worked on, statement of remorse, a letter of apology to the victim's family, or a relapse prevention plan, that comes up a lot, and we can talk more about that today. But the more you can bring to the psychologist to show, I've done this work, then they're more likely to put some of that in their report. But even then, it's kind of hit or miss, especially the very first parole hearing. And that the client I was talking about, that was his first parole hearing. He'd never been to the board before on a first-degree murder. It can happen. But the psychologist there, just the comment was concerned that he hasn't debriefed, suggests some allegiance to gang stuff. The board should explore this further. That's kind of how the psychologist left it. But you very much need to prepare with everything you can for the psychologist, just as much as for the parole board. And the psychologist will come see the client. Nowadays, it's 3 or 4 or 5 months before the hearing. Could be as far out as 6 months. I think they're moving in that direction. But now it's around 3 or 4 months before the hearing.
Okay. So we had received an announcement or notice from a prisoner who'd gotten this thing from the parole board. They had scheduled his hearing. They had advanced his hearing, and he was validated, and they advanced his hearing. And they said, we want you to come back and answer these questions. And they gave these what we're calling the 4 questions. I had sent them to you.
Yeah.
What was your take on that? Have you seen that before?
Well, I was very curious about how they communicated those questions to him. Was it in the miscellaneous decision that said we're advancing your hearing to address these questions?
Yeah.
I've never seen that before.
Yeah, I'll send it to
you. But this is someone who had been denied parole?
He'd been denied, but he'd gotten a 3-year denial.
Yeah.
And it seemed like the parole commissions were recalling, advancing on their own motion, people who'd been gotten a 3-year denial.
That
and
is
maybe
standard.
Didn't have any write-ups or anything in the previous.
That they do. That is standard. It's almost automatic if you get a 3-year denial, especially if you got a low risk assessment on the psych evaluation. As long as you don't get any 115s, you will automatically be advanced. So that 3-year denial will be an 18-month denial.
Right. So that's what happened to him. And in that notification, it gave those questions.
Mm-hmm. Yeah, I have never seen that before. I mean, I know that you mentioned that, but I've never seen that before. It certainly doesn't surprise me that they're trying to figure out how to handle these cases.
And we gave copies of that. They were on the table over there. So.
But if you look,
Carol, can I ask you a question?
Yeah, sure.
Question is that I'm seeking is, does it make a difference to have an attorney with you in front of the parole board?
oh, it absolutely makes a difference to have an attorney
And
with you.
thousands of people come from the board don't have that, right?
Well, I mean, if you look at
So
every year they conduct about 6,000 hearings. The board does. Now, everyone has a right to have an attorney to represent them, and the board will appoint someone if folks can't hire or find their own. But it's important to go with an attorney because sort of the work I talked about before, the things I explained to the board, the client can't do that. And also, obviously the client can't say, you can't ask me about my debriefing. You can't do that. There are two roles here. That there's this is one of the most controversial things I say to my clients. I said, look, you can't be in there advocating for yourself, right? As crazy as that sounds. I said, your job is just be yourself. My job is to advocate. My job is for them to say, what you just saw and heard and learned and who you just met, that's somebody who's supposed to be out of here. And let me explain why. That's my job. Your job is just to show who you are. And they have to get that you're genuine about that, not that you're arguing, you must release me because. People who say that are denied parole. So there are two roles that my client can't do both of those things.
Okay.
thank you.
Sure.
All right. Let's see.
Well, I want to talk a little bit about these questions though.
Okay. Yeah.
The first one, how have you broken away from the prison gang? The first thing I would say is, I mean, you have some people who are saying, look, I was never a part of a gang. Validation was always bogus, etc. And in that case, you may say, well, look, I'm not going to answer that question, or the attorney should say he's not going to answer that question because he was never in a gang. But the real question is, why did you go along with the politics? And how did you get away from that? When did you decide you weren't going to do that anymore? When did you decide you were going to stop following those rules that kept you, associating with the people you did, exercising when you did, working where you did, getting the rule violations that you did? That's the real question. And if you're not going to tell the truth about that, you will stay in prison. It's not really about gang validation. Gang validation is their substitute way to say you made a course of, you chose a course of action. You chose a group of people to associate with. You chose some activities in prison that we would recognize as, not pro-social. When did you stop doing that? And why? Like, they're not really asking, did you choose that? They already know that. We all know that. It's prison. You come in when you're 16, 18, and you've been there for 30 years, you did that when you came in. That's not a question. You did that. Be honest about it. And then they can hear you. But if you, no, I never did that, hearing's over. Hearing's over. So they're really asking, are you willing to tell the truth about where you've been, how you've changed, and why, and talk about that progress, or not? And so these questions, I think this is sort of their shortcut way to say, who we got coming in here? Somebody who's ready to be straight with us, or somebody who's playing games. Now, I wouldn't recommend that, that any of my clients answer these questions, certainly ahead of time. I don't know if they were asking for questions or answers in advance.
No.
Okay, but they were giving you a heads up. Here's what we're going to ask you to address in the hearing. Some of those, they would ask, for example, the second question, what efforts have you taken to not affiliate with the prison gang? I would encourage my client to answer that, because it shows, it gives them an opportunity to say, when I came in, I followed the rules. I did this and this and this kind of stuff I did. And when I recognize, that's not going to get me home. It's getting me further away from my family. I changed my life. Now here's who I choose to associate with. It allows them to tell that story, which is an important part of their story, their journey. And I don't mind that question at all. But if you just keep coming back to, the client has to have an opportunity to tell his or her story in their own words, not sticking with some squabble about was it gang, was I a member, was I an associate? None of that really matters. Not really. Not really. So you can get past that when the person's telling the truth about it. You have a question?
I just want to know,
can the severity of the case override your transformation, the change that you've made? And legally, not supposed to. As a practical matter, absolutely it does in some cases. Some cases are too high profile, too politically charged for the parole board to feel comfortable granting parole, or if you can get through the parole board, too much for the governor to let go. In those cases, you have to go to court. We do that a lot. Yeah, we actually got a favorable decision from one case of ours, a guy named John Clouchet. Some of you know who he is. We're in Superior Court challenging the governor's most recent reversal of his parole grant. We got an order from the court that was favorable just yesterday. But that's kind of what it takes. Certain cases are so high profile that you have to take them to court. At the same time, we're going back to the parole board every opportunity we can to get a favorable decision. So we kind of keep a couple irons in the fire. What does it mean if you were a juvenile when you had the case, and now obviously you're much older? Shouldn't that be given some different weight? And there's some laws that require them to treat cases of young people very differently, to give great weight to the fact that you were young and impressionable and impulsive and didn't anticipate consequences, et cetera, partly because your brain development before age 25, the parole board is supposed to give great weight to that in deciding who's suitable to be released or not. But oftentimes you got the high profile nature of the case that is still exerting its own weight in those cases. It remains to be seen how some of those are going to play out, because some of those new rules they're still new. There's some cases in court that hopefully will shed more light about how much the parole board can ignore those kind of youth factors.
No, not good.
For people who don't have representation, what should they do in response to these questions? Why not debrief? As I said, everyone has a right to have an attorney. The board will appoint one. That attorney may only meet with them one time before the hearing, and they'll show up on the day of the hearing. But in that time you have with the attorney, let them know, look, this is an issue in my case. What are we going to do about this? Either the client has an idea about how they want to handle it, or the attorney may have an idea. But if the client understands or has heard from anybody in this room, they'll say, you should tell the attorney you don't want to answer those questions because it can kind of neutralize that issue for them. It's not going to force the board to do anything, but it removes one of the issues that they would be talking about or concerned about. But I strongly encourage people
They won't use it against them for not.
Well, they won't use it against them, the fact that they're not responding to it. I think that's the kind of issue that could potentially lead to a court challenge if they do use it against them, something that the state seems to have said we legally can't require this. The fact that you won't talk about it shouldn't also be a basis for denying parole. But again, a lot of this stuff is brand new, and sometimes we have to test these things in court. And the case I talked about, the governor might reverse their client's parole grant, and we'll either have to go to court, go back to the board, something like that. We don't know how all this is going to play out. I've given you an example of how it can play out, a way to do it, but a lot of this is yet to be determined.
Well, it's interesting, that example, because it seems to me that there's good reasons why somebody might not want to debrief, but are you saying that I don't need to know your specific client's situation, but in general, it seems like, if you're worried about something may happen to your family, or you feel that, these were your friends for a while and you don't want to do anything to hurt them, or, you don't like, that those kinds of reasons should be, good enough, should satisfy someone's curiosity and be a reason that doesn't negate, their release.
Right, and you're right, but the risk is in explaining that, if the client is explaining that, he may say something that the board will pick up. Oh, that sounds like you're still adhering to the criminal code, that you showing more allegiance to these gang members than larger society, and that's a concern to us, and so we need to see you change that. There's no upside really for me to have my client to wade in there. It's better for me to talk about it. There's a lot of things I can say, I can describe, I can sort of defend that the client just can't do. Shouldn't do, because any of those, if they're looking for a reason to deny you, responses though, as reasonable as they may be. I think one of the things we might talk a little bit about is sort of the question of how you would handle certain situations. Oh, if you saw a crime on the street, would you report it? That kind of thing. Those kind of questions come up, and they're really getting at whether the person in front of them understands how they think people should be acting, not how they would actually act. Like most of us would say, oh yeah, I'd report it. Most of us probably wouldn't report stuff though, right? But we know that that's the right answer. But a lot of people who've been in prison for decades, in my experience, they forgot that was like the right answer. Because it wasn't the right answer for them. It for real wasn't the right answer for them. It wasn't a real answer because they know that gets them hurt or killed. So their ability to understand that actually there's a different way to be. The board is listening to see, do you remember that there's actually another way to be out there? And can you share your understanding of that with us? But some of these they're tricky questions because the answer, however honest it may be, can be the kind of thing the board points to say, oh, this shows somebody who's too concerned about that. If you honestly say, well, I know if I were to debrief, then that puts my family in jeopardy, that puts me at risk. I got a brother here in prison, and he's like, that's true. But that, in their view, oh, that's why you were associated to begin with. Because you were afraid of standing out, afraid of standing on your own, afraid of, So there's not much upside, in my opinion, to most clients talking about that stuff.
Okay, so the question has to do with a prisoner may be, in fact, honest and truthful, but what he's saying, it contradicts the confidential memos in the file.
So that of course happens a lot. Part of the reason, my experience, what happens is when people are asked about their activities in prison, for example, they often don't tell the whole story. When they say, when the commissioner says, you ever been involved in drug trafficking in prison? We know on the streets your case was drug related, it was a drug deal that went bad, and ever been involved since you've been in prison? No, I haven't. And the person has no 115s for drug activity, okay? But the commissioner's looking at, a confidential memo that says in June of 2003, this person was, selling drugs on the yard. And they look at that. And they ask you ever been involved? No? Okay. Well, we find you're not credible because the confidential information indicates otherwise. Now, they may not even be that specific in explaining why we find you not credible. They've just seen this and aren't talking to you about a memo from June 2003. They just sort of file away, okay, we asked him about that, he lied about that. But what usually happens in the cases I work with, we get a list of everything that's in the confidential folder. It's not that detailed. It just says June 2003, for example, there's something in there. So I asked the client, and when we get to the parole hearing, the question comes up from the board, you ever been involved in drug trafficking? No, I haven't. But back in 2003, I remember somebody dropped a kite on me saying that I was involved because they wanted to get off the yard or something like that. But yeah, nothing ever came of it. Now, they've just neutralized that whole thing. As long as they didn't get a 115 for it or a 128 for it, that's done. Because he acknowledged there was something in there that I know about, had nothing to do with. If he didn't do that because he didn't know about it, then the board will say, oh, this happened and he's lying. This guy's not credible. But you establish credibility by addressing that. Even you're not admitting that. In some cases, in other cases, my client admits, oh yeah, back then, yeah, I was still selling drugs. No problem. Really. Like really. I tell people you could, as long as it's far enough in the past, you can tell the board just about anything. I'm not saying make up anything. You don't have to. There's plenty of truth out there, right? Plenty of bad stuff that's true. But they're trying to figure out, are you going to tell the truth about it? The dirt you did when you came into prison, own up to it and you're fine. Now, I mean, I even had a client, I may have talked about this before, but a client who came to prison on a gang murder and while in prison committed another gang murder. Still went home. Because he had changed so much in the time since he did that. And it was genuine, it was real, they got it, went home. So with that having happened, nobody can tell me anything they've done in prison that bothers me. Like that you may have to, put some time in, some distance since that thing, but there's really not an upside to lying about things you were doing in the past. And you actually establish a lot of credibility when you own up to things you don't have to, things that aren't documented anywhere. You neutralize a lot of the confidential information. I mean, the example I gave earlier, this guy, he'd already painted a worse picture of himself than was even documented in the confidential file. So it wasn't of use to the board in determining whether he's safe to be released. Now that's different from the person who absolutely didn't do the crime and is obviously trying to show insight and remorse, et cetera. And we can talk about that because I've definitely had those cases too.
So the prisoner and the lawyer gets that list or those documents, those 1030s of what is alleged in your confidential file?
So there are two different pieces to this. The 1030 is a disclosure form. It says this date we received information that says X, Y, and Z. A lot of people who are validated with that information, people who get rule violation reports that are based in part on confidential information, will get a 1030 disclosure form that says, here's what's alleged. You were associated with gangs, you made a weapon, you're selling drugs, whatever it happens to be. There's some substance that you can say, oh, okay, either I did that or I didn't do that. But you only get the 1030 if some action was taken against you based on the information. If they didn't act against you, put you in the hole, issue 115, then the only information you get about that is the 810. The 810 is a list that just says on this date something was put in your file.
But if the parole board might use something,
and you do get that, you do get the 810.
you get the 810. But if the parole board is reading those confidential memos, and maybe even I don't know how deeply they can go into those, but and then they use that against you,
yeah.
Aren't you supposed to get that in advance too? Is there now some new protocol about getting stuff that they might use against you?
Well, what they've started doing back in, I think, July, prior to each hearing, because they know that a lot of institutions were not providing 1030s when they should, and a lot of them weren't even providing the 810. So people really were in the dark about what information might be in the confidential folder. In July, they started to create their own version of the 1030, where they would look at the confidential information in the file and write up a summary and say, information in the file, these dates, indicates this information about you. So you get some little bit of a hint of what the concern may be. And you get that in the 10 days before the hearing. That's what's supposed to happen. That's a new procedure.
Okay. So actually what I was going to lead up to is we have family members and supporters in the room, and one of the questions is how can family members help? People do get lawyers, but the lawyers may only do one interview, and they may not do a thorough interview. And I think this strikes me as possibly something that a family member could help a prisoner with about, well, what are the 1030s you already know about? How are you going to talk about them? That sort of thing.
Yeah, that's true. Although, I mean, a lot of people keep a lot of things from their families too.
Right.
Right. So there are a lot of things in the file the family doesn't know about, and confidential or otherwise in the file that the families don't know about. Sometimes clients don't want their family members to see their psych evaluations, for example, or the transcript from the hearing, because there's embarrassing stuff in there, or just stuff they don't want them to know about, even though it's available to the public. Right. So the encouraging them to address those things, absolutely, family members should do. The other thing, I mean, we talked before about what the family members can do for people who are going to the board. If they know that they don't have great access to programs, get them the correspondence stuff, get them the books to do some of this work, because it actually, I mean, it just makes a difference.
Right.
It makes a difference. But in working with them in his anticipation of the hearing, encouraging them to talk about those things, especially, I mean, if you encourage them to focus on the most shameful stuff, that's where the magic happens, sadly.
Yeah. And I know that I think of your work as the sort of the Cadillac of parole representation, and partly is you have volunteers and you have students that you work with that you're able to send in to have pre-interviews with a lot of clients and help them. Is that the case?
I mean, I guess if you look at it this way, what we do is we do more counseling than lawyering, and it's not really just an interview. It's actually like a counseling session, and we do a bunch of them. So students, we work with teams of students who go in and work with the client over the course of about a year, typically with the students, and they'll see them in that year maybe 12 or 14 times for a couple hours each visit, working on this stuff, figuring out how do we talk about, how do we understand and talk about lifestyle choices you made, et cetera, programs in prison, disciplinary, gang stuff, all of that. So we do that with the students, but that's also what we do. So I have a social worker on my team. I have other attorneys on our staff and who volunteer with us, and that's what I do. I work with clients, and it's sitting across the table figuring this stuff out. Family members can do that for sure. Most attorneys, the board appointed attorneys don't do that because they're not set up to do that. Yeah. They're hired to see the person one time before the hearing, to read their file and prepare as best they can, and to be there to represent them on hearing day. It's a different relationship. You don't expect that to produce the kind of long-term engagement, involvement, and sort of kind of therapeutic relationship that some other attorneys like on our team can do.
Right. So it strikes me as a kind of way that family members can try to figure out some way to supplement
Yes.
what a parole board attorney will do.
Yes, yeah.
Instead of going, the lawyer's not going to see me, he's no good, they're
Right.
you know, blah, blah, blah. There's a lot of negative feelings about some appointed lawyers, just like public defenders. But if you take them for what they can do and supplement it somehow, it seems like that would be, and maybe a family member sends in somebody else to talk to them because they, you know, who's not a
Absolutely.
family member.
Yeah.
Yeah. All right. So I want to just a couple more questions, and then we're going to move on to our next speaker. But we'll have some time at the end too, I hope. Yeah. Are you Sharon? You're pointing.
Yeah, because she got
yeah.
question coming over there. The question was, what is this lifer program that I mentioned earlier in describing this one person who had recently been released from the SHU? It's kind of like it's sort of a different path. It's I'm not participating in the politics. I'm not running with any particular group that's involved in violence or gangs or drugs. Or our program as lifers is to participate in self-help, education, vocation, getting ready for the board, supporting each other. Like, that's the program that they're on. That's what they do. That's who they associate with. And in some places, this is not, every place is a little bit different, but in some places, people who commit to that program are allowed to do that, by other people in prison to do that, and not have to follow the regular, regimen of whether it's exercise, whether it's violence, whether it's drugs, whatever it happens to be, that other people of that group would otherwise have to do. That's what I mean by that.
Okay, but right now they have something in there that's called SONG.
It's how you operate in prison. It's the collection of those kind of groups that you might be involved in. People choose that over, I'm going to hang out on the yard and get into whatever there's to get into, that kind of thing.
It's not sanctioned by anybody.
For this is more like an informal, casual reference to how people are doing their time, not I'm in this program and therefore I'm not doing something else. You may have you know more about this than I do. What if you're on a yard where the politics, the kind of unwritten prison rules are really strong and strongly enforced, and you go to the parole board and you want to be honest with them, but you also have to give them, kind of the realistic answer of how life is in prison. It's a very difficult challenge. It's also why it's why when the parole board goes to a level 4 prison, they are not expecting to hand out many parole grants, because they assume anyone who's been there for any length of time is involved in the politics in one way or another. And if you're not honest about that, if you say, no, I don't know anything about that, I've never done any of that stuff, okay, this hearing's over, no problem. The other thing that's related, though, is as long as you're on those yards, you're going to get 115s for something, either participation in a riot or something else, something more specific, maybe an assault on somebody, possession of this or that. That's going to happen. And so if you have a rule violation report, a 115, anytime within just a couple of years of your parole hearing, you're going to be denied parole too. So there are a lot of other things that communicate to the parole board, this is somebody who's not ready. He's still on this yard, and he got a 115 last year. And it doesn't matter what it was for, he got a 115 last year. For somebody who doesn't have that, but they're on the yard, they're leaning against granting parole because they think you're up to something that you're not disclosing. It's a huge bias against granting people parole at a level 4. There's a process now that allows people who are at higher security level prisons to come down to a lower security level. At their annual classification, they look at them, and if you stayed clean, you can do that. Sometimes the parole board is saying, we need to see you get down. We need to see you, we see you've been clean, but you know, we need to see more programming from you. We want to see you take advantage of lowering your security level. It's not fair, and I don't have a great answer as to how you get around that. But I have seen people just honestly say, you know, here's who I associate with because that's who I have to associate with on this yard or I'll be killed, right? But I don't participate in the violence. I don't participate in this stuff. I go to the yard when I need to. I do exercise, you know, that kind of stuff. But this is sort of another version of the LIFER program. But they respect them trying to go home. And so I don't have to be involved in some of the same things as I used to be involved in. But a related issue is, this used to happen for people who were never validated, but they were on the level 4. And the commissioners would ask, basically, what are you still doing here? And how are you not involved? The honest answer in a lot of cases was, look, I went to the guy running the yard and said, I can't do this. I'm trying to go home. I got a family to get to. I need to be on this program. I've done your time. I'm not going to, you know, step on your toes, but I don't want to be a part of that. Again, this is a version of I'm on the LIFER program. So that version has kind of existed for a long time. But what happens is people go to the parole board, they don't want to acknowledge, yeah, I had to tell somebody, right? But when you say, yes, I had to do that, there was a reckoning. When you say that, you establish credibility because they know you're telling the truth. Sometimes it's, you know, I've had this happen. Sometimes they say, yeah, I had to go to the guys in the yard, say I'm not involved. And what happened? Well, I got jumped. And then they left me alone, right? Somebody, I got stabbed, right? Like, that's crazy, the stuff we're putting people through, right? But that's the reality. It's a description of, okay, this was my journey away from that. And it's credible. It's what actually happens. They get that. And you have a record now that shows this is somebody who's explaining how he got away from that, how he's distanced himself from that, and somebody we can say may be ready to go home. That's kind of how it goes. Yeah, so the question is about how much we know about who we're going to appear in front of, and do we prepare for particular commissioners, and the board now tries to keep it pretty secret who we're going to see until the week of the hearing. If you have a hearing that's later in the week, those commissioners have been there all week. So if another person at that institution has been to the board on Tuesday and your hearing's on Thursday, they'll tell you who the commissioner is. So we know by then. But we generally don't prepare for any particular commissioner. You kind of have to be ready for whoever you get. You're ready to be as honest as you can be. But at the same time, there are some who have a style. Some are much more aggressive, confrontational than others. And so when I see that commissioner, I'll tell the client, okay, she may do this or he may do that. He may ask you this way. Don't let it shake. Really, all I'm saying is don't let it shake you from who you know you are. Don't let them knock you off your game. They're going to do this. Don't worry about that. But we don't really try to target any particular commissioner. They all have their issues. First, you just said you went to the board 21 times. Took you three grants before you finally got home. Welcome home, for one. I'm really glad that you did that. That it worked out. It's terrible that it took that much. But you also raised the point about the kind of support people have on the outside to help make it happen. It is a huge part of this. If the board feels like you don't have anywhere to go, you don't have a support system, somebody to not just keep you going in the right direction, but to help you get there, then they will feel like, well, you may be better off here in prison. Like that's their view. But at the same time, people who don't have that connection to the outside, their motivation to go through the parole board is different. I've unfortunately met people who, had a client who was, he's been in prison for many, many decades. And he said, look, all my family's gone. I don't know anybody else outside. And his motivation to do the things that it takes to get to the parole board was not the same. His outlook was not the same. So that happens. It doesn't happen often, but it does happen sometimes. It's sad when it does happen. Well, the issue about, you also talked about the psych evaluation. The psychologists, they diagnose people, and Dr. Kupers will talk about this, I'm sure, with antisocial personality disorder. That's really about, are there certain historical factors in your case, certain things that happened in your past that fit into this group of this collection of factors that we can say, yeah, that's the label we want to put on it. It doesn't really do anything to help them predict the future for California's lifers. But they just put it in these reports all the time. I would say from my experience, most lifers, like you said, get this diagnosis, this label, antisocial personality disorder. But a lot of people still get to go home. Fortunately, you're here. You can overcome that because they really want to know, who are you now? So that label really applies to history more than anything else, in my experience.
And we will, I'm sure, hear more about that from Terry. Okay, thank you. So turning to Danny. So Danny, you were in the SHU for a while, and can you tell us about your SHU experience, particularly on this kind of programming issue? What kind of positive things were you or others able to do in SHU that would be helpful to present to a parole board? And how can we find ways to talk about that SHU experience to show it that it had some value?
Well, I think you covered a lot of great things, right? So I'm going to talk about it, I guess, from the person that's in the SOAP, from that perspective, right? Because a lot of things that he talked about was things that I was going to also address. But I was not, well, one thing we got to understand that I wasn't a lifer, but I was in the SHU. I did a 14-year sentence. 7 of those years were spent in solitary confinement at Pelican Bay, or at least 5 of those were in Pelican Bay, where I paroled from in 2010. So when I got to Pelican Bay, there was already programs going on. I arrived 2005, April 2005, and at that time there was a GED program. There was the correspondence programs through Coastline Community College and I think Feather River Community College, and there was also a program called the Estelle program, which was a pre-release program for people that were coming home that were like 2 years or less to the house. And then, 2008 comes around, economic crisis, everything gets shut down unless you're going home. If you're 2 years to the house in SHU, you still have access to GED program, you still have access to college programs, but it just reduced the number of participants in the programs, because the majority of the participants were lifers that were in the college program, the GED programs, right? So that had a very hard impact or hit on just the programming of people in there. Like, it went down to only 3 pods in one cell block that had access to the college program, and that was the pre-release program. So for me, I did a lot of that reckoning that you talked about, right? Like trying to look at, what role did I play in, ending up where I ended up at, right? And at a young age, prior to the age of 13, I was an innocent bystander in 3 drive-by shootings, right? So like, I always grew up with this fear, like, I don't want to be that. I don't want to be that. I was an innocent bystander. For the most part, I was just a kid playing basketball, playing baseball in the streets, and wrong place, wrong time. But by the 3rd time, it was already normal, right? I said that, like, okay, this is my life. Like, this is like, I had friends, you know, who were innocent bystanders, had gotten murdered at 14, 15 years old. So it became just a way of life. And we, little by little, we gradually, a group of people, or young men in my community, gradually adapted to that lifestyle that, you know what, this is what it is, right? And, you know, and we gravitated toward that in full force, right? Like, you know, by the age of 16, I was arrested for 2 armed robberies, a carjack, and an adult nap, right? And I was sentenced to, I was given a plea bargain of 15 years with 2 felonies, where I was looking at 75 years to life. I had 3 co-defendants. I was 16. The other 3 gentlemen were 18 and over, and they probably already had a combined time of experience of about like 10 years of incarceration. 2 of them were California Youth Authority wards, and my other friend had spent about like 5 years in the California State Prison. And so it was very easy for me to get tried as an adult, because this is the people that I was, you know, hanging around with, right? People that already had all these violent crimes or, you know, records on that served time. So I went into prison wanting to be that dude, you know, like, this is, you know, this is my life. This is the rest of my life. I want to be that guy. I want to, you know, get involved in the life, you know, in the politics and all that. And that's how I ended up getting validated, right? But my validation, you know, even though I wasn't as heavily involved as I thought I was, you know, I was the guy, like, if somebody told me, hey, take this out to the yard, like, okay, yeah, I'm going to take this knife out to the yard and I'm going to hide it. And, you know, that was like pretty much like the depth of my participation, right? I wasn't, you know, running the yards or anything like that, you know, but I was very active. If somebody asked me, hey, do this, you know, like, yeah, of course, you know, that's part of the lifestyle, you know. But I think once I got validated, though, I was already coming out of my, had got out of the hole and went into the hole in 2000, March of 2000, did about 9 months. Then it came out, and I was out in general population for about 2 years. And then the summer of 2003, I had gotten validated based on all kinds of information that, you know, confidential information, some Aztec drawings, a dictionary that had somebody's name and number who I didn't know, but he had just recently been validated on that facility. So that was like a direct contact for me. So these were all things that, you know, things that there was no actual rule violation, right? Where I assaulted somebody, or they caught me with drugs, they caught me with knives. It was just all, you know, information, you know, that gets atomized as gang activity, right? Yeah. So I get placed in solitary confinement in 2003, and, you know, it wasn't really like, it took a process for me before I got to the point where, like, you know what, I don't want to do this no more. I don't want to do this no more. But it wasn't until I got to Pelican-Bay-SHU where people were asking me, like, hey, what do you know, you're going home in 5 years, what are you going to do? And for me, it was like, I just don't want to come back to prison. And people were telling me, well, what's your plan? And, like, I don't know, I'll figure out when I get out. And people were telling me, like, that's not going to work. You're not going to go home from here and think that you're going to just be able to get out and not come back if you don't have a plan. So you need to start, you know, building a vision or a goal for what it is that you want when you go home, right? And even understanding, though, that it might not happen, right? You got to have, like, the skeptical hope, right? Like, I'm hopeful, but I'm also skeptical that because of my record, because of my past, that doors are going to get shut in my face, right? But nonetheless, what can I do while I'm here to prepare myself to mitigate those barriers? And I think that's the same approach that people that are going to go to parole should also approach it, right? Like, I have this history of violence and, you know, activities that the parole board is going to frown upon, but now that I've decided to change my life, what am I going to do from here on out to mitigate that, those 115s and all that? So what can I do? And for me, it was really preparing myself through education, right? I got my GED in 2008, and I had about 2 years left of time to serve, and I ended up enrolling into community college. I did 4 semesters, came home with about 48 credits, and which I wasn't really thinking about, just, you know, for me, was just trying to get up my GED and the certificate, which was 18 credits. But I met this man who was a lifer, who I ended up getting moved within the SHU, and I ended up next to this guy who was a lifer, and I told him what my plan was. Like, I'm gonna get my GED and my certificate of accomplishment in general business, and I'm done, and I'm gonna go home. And he was like, nah, I'm not having that. You're gonna get your AA before you go home, or at least as many units that you can get, so that you can accomplish your AA once you get out. And I try to make up every excuse, right? Like, I don't got the books, I don't have, the resources. And like, yo, I got you. I got all the books right here. I already have my AA. Like, I got you, whatever you need. Your mom don't got to pay for books or anything. So, yeah, he really encouraged me. He really pushed me to pursue my education. And when I came home, for me, continuing my education was the best decision that I could have made, because it really was a place for me to make connections with, counselors, professors, just staff that worked on campus that really became my support network and also my professional network, right? So I got my first job. I went in at 16, got out at 30. No work experience, right? My whole life, right? No work experience. And I get my first job on campus through the Federal Work Studies Program, which is a program that you're allowed to participate if you can get financial aid, right? And I was not barred from receiving financial aid because my case was not a drug case, and I wasn't receiving financial aid during the time I caught my case, right? So it's important to understand that you are eligible for financial aid. Just a lot of times we come home thinking like, oh, I can't get this, I can't get that. Like, no, actually, you can get a lot of things. You just have to do the research, and you'll find out there's a treasure chest of resources out there that you can tap into. And so I got my first job on campus. I ended up getting 3 different jobs on campus. That allowed me to create 3 different references, right? And it allowed me to have a resume where 3 different positions. And then, after 2 years in community college, and after learning all the resources that are there that are going to allow me to transfer, I ended up transferring to UC Berkeley. And so we transferred to UC Berkeley in 2012. And immediately after I got there, I met a friend who was also in solitary confinement, my friend Steven Sifra. And me and him, together with a group of other students who were formerly incarcerated and system impacted, created a student organization called Underground Scholars. And about a year after that, when we created the organization, we got funding from the university to create a program. And one of the things for us was always taking into account that, first and foremost, we wanted to serve the students that were there, that were formerly incarcerated, but also once we started to expand, understanding that we can play a support service role for the folks that are coming home, right? So we started an in-reach program. Our in-reach program is our prison correspondence program with people that are in prison, in particular with people that are lifers. So people that are taking college courses in prison and that are lifers, we encourage them to write to our program, to the prisoner correspondence program. I can give out the address after I'm done. I don't know it off the top of my head. And we encourage lifers to write us and to tell us about all of the accomplishments that they've done while in there, whether academic or just personal accomplishments, such as getting a Alcoholics Anonymous certificate, an A certificate, or a restorative justice certificate, whatever it is, right? Write to us and give us a list of all your accomplishments, and we will write a letter of support to the parole board. Look, we've been lucky, we're not just, we're in an opportunity to be able to give back now, and it's shown, right? We've written numerous letters to people that have gotten paroled. And we're not saying that it was just our letter that got people out, but it is, it's part of that basket of resources that the gentleman back here was talking about, like, having those resources out here that are gonna help you get back, help you hit the ground running and be able to put you in positions to be able to tap into the resources that are available, right? And also taking into account that although we're at Berkeley, and not everybody that's in a parole is going to be able to go to Berkeley or go to Berkeley. Some people might go to San Diego, or they're going to parole to San Diego, parole to LA, parole to Shasta. So what we've done is we've been able to connect with all the other student programs and formerly incarcerated student clubs throughout the state, so that when somebody does get out or is about to get out, we say, look, we tell the parole board, he might not come to Berkeley, but if he goes to San Diego, there's Urban Scholars, a student organization that are formerly incarcerated students there that we're going to connect them with. We're going to connect them with the Underground Scholars at UCLA if he goes to LA. If he goes to Santa Barbara, we're going to connect them with the Transitions program at Santa Barbara City College. So these different programs for wherever people are going to go to, that we try our best to be able to connect them once they get out and have somebody out there waiting for them at the campus, right? Because nothing more important when you get out of prison and you decide to go to school, to see a face that you can relate to. Right, when you walk in through that academic door to the admissions door, to see a face that you're going to be able to connect with and be able to understand that, look, I don't know how to use a computer. I've been away for 30 years. I don't know how to, So somebody there can help you with that process, because that can, just that little interaction can put your plans to the side, right? You know, can pretty much bring everything to an end, where if you go to a campus and they're like, you know, I need help with filling out my application for financial aid, like, oh, there's a computer, get on it. And now you're like, well, you might not want to say like, yo, I don't know how to use a computer because I was in prison for 30 years. So somebody might say, you know what, nah, I'm not even going to touch it. I'm just going to just keep on going and figure out some other way to do it. So really also teaching people, right? Really teaching people that asking for help is not a sign of weakness. It's actually a sign of strength. When knowing that you can't do something on your own and being able to understand like, yo, I can't do this on my own, I need to ask for help, that is not a sign of weakness. So it is a sign of strength to understand where you can't do something, that you can rely on your community to help you in that process. And that's what we try to do.
Okay, I think these are really terrific tips, and I think that these formerly incarcerated clubs, this is really new, isn't it? Yeah, and I'm not quite sure how that's come about, but it's really wonderful now. And I like the fact that you said that even someone who's been in for 30 years, because it's never too late to go to college, right? Do you think?
No, definitely not.
Yeah, and that could be for someone who's coming out and may not have a job or something. If you have some support, that could be what your parole plan is. It sounds like. I don't know how many of the older prisoners are thinking along those lines, but that's something to consider. And I just want to say, I meant to say this earlier, we had invited also, I'm forgetting his name, no, I mentioned him, to come, and he wanted to come up from LA because he's a person who was validated and did get parole recently. But he wasn't allowed to travel, you know, he's out recently, it's changing counties, parole board wouldn't let him come. So, so I just wanted to mention that. But this has been really helpful, Danny, and I don't think the other questions I came up with are as, you know, useful as what you just talked about. Do anybody have some additional questions for Danny? Yes.
I just wanted to ask Danny, how many schools?
Student programs, which are student support service programs, or student organizations exist in California. I don't know it off the top of my head, but there's a website called Corrections to College that we put together where I work at the Opportunity Institute, and right there it tells you all of the campus programs, all of the prison programs, and all of the county jail programs.
Well, Danny and Steve Zifra, Sparky, came out of the woodwork when the hunger strikes were happening in 2011 and started becoming speakers, and that was just really an additional real oomph to the movement that, you know, was created on the outside, and it's just so remarkable to see where it's all gone. And UC Berkeley did give an award to the Underground Scholars Organization a couple of years ago. What was that award? That was the Chancellor's.
That was in collaboration with All of Us or None. It was a community award, and it was an award based on the work that we've been doing with All of Us or None. Actually, one of the things that we did at UC Berkeley, one of our programs is our program operates on it's a bucket list of 3 things, right? Recruitment, retention, and policy advocacy. On the policy advocacy side, we were able to, Underground Scholars was able to get the university to ban the box for employment for people that want to be professors or staff at UC Berkeley. We were able to get them to ban the box. And then the following year, we were able to get them to ban the box statewide at all the UCs, right? So that was, when we did the ban the box at UC Berkeley, that was something that, you know, again, one of the things that All of Us or None has been always doing was ban the box, right? So we took their idea of, you know, of ban the box, and we just applied it to UC Berkeley.
And students really over the many years have been going up to Sacramento once a year, you know, saying, you know, education, not incarceration. So there is some level of, you know, college student support for this idea, I hope. Yes, but, okay. All right. So that's, thank you very much, Danny. So now we're going to go, okay. So Terry, you know, I can just introduce you a little bit more. You've been involved with prisoner support work for decades. You've particularly somewhat specialized, I would say, in solitary confinement. You're a national expert, and you have worked on many cases. You work a lot with lawyers, and you are just, and you're more than an expert. You're an activist as well, and educator and counselor and therapist and everything. So you're really a great example of you know, how we always try to be. And Terry was one of the experts in our Ashker case, and I worked with Terry. I got to know him. We got to travel together, and it's been wonderful. And now you are currently helping some prisoners, lifers, help get them parole, as we've heard, and you have been working with our committee on trying to change the system a little bit. So, with that background, can you give us some basic information about what is the FAD, what's a CRA, and who are these psychologists that prepare the report? How do they do it? What's that system all about?
I'd be happy to. First of all, let me say I'm happy to be here with all of you. And Carol was a dynamo in the Ashker case and other cases. I agree with Bato that what Danny did was very courageous. One of the biggest
I got a mic up.
Oh.
One of the biggest problems that people have who get out of prison is isolation. You have to break the isolation. You have to be involved with people to make it. So the program that Danny is involved with is really important. We're in a culture war, and there are two stories. One story is that prison is filled with heinous criminals who are awful. They're murderers and bank robbers and such. They're absolutely incorrigible, and the best you can do with them is lock them up, preferably in solitary confinement, to protect society. And in order to do that, we need to multiply the prison budget, geometrically. That's one story. And so people who get to solitary confinement are called the worst of the worst and such. There's another story, and I hear this from universally from every prisoner I've ever talked to. When I was a kid, I did stupid things, most of them on drugs. And then I got caught up, and Danny said a little about that. I got caught up in the prison, in the culture. For various reasons, I got into more and more trouble. And that's another story. And then you meet people who are 35, 40 years old in prison. They've been educating themselves. They help other, particularly younger prisoners. They're really neat people, and they're very bright. And I meet people in prison who don't have a college education, but I can talk with them about anything, philosophy, literature. They're just extremely educated and bright and caring. That's another story. And if you help those people tell their story to the parole board, you're going to help them get parole. So for instance, antisocial personality disorder. It has character traits, personality traits, like callousness, a lack of empathy. I haven't met those people. I meet prisoners, they're extremely caring. They're interested in how I'm doing during our interview, and they're taking care of me. Are you comfortable? Are you okay with this? And I'm saying, wait a second, you've got antisocial personality disorder on your chart. Something doesn't compute here. So my job, and since we did the Ashker case, I've been doing more and more parole work, because if we help people get out of the SHU and they don't get out of prison, what have we accomplished? So I've been focusing, and the committee is really doing great work to kind of educate people and struggle with the parole board about what's going on. Parole has a number of considerations. One is risk. Risk is a very important consideration, and actually the criminal justice system bends over backwards so that the kind of scene that happened in Las Vegas won't happen. Now, it's absolutely impossible to prevent what happened in Las Vegas. In fact, from everything I've read in the paper, the guy who did the Las Vegas massacre absolutely makes a lie out of what we're doing with our psychological assessments. He doesn't have a violent background. He doesn't have a criminal background. There's none of the precursors of violence in his life, as far as we know yet. So, there's a lot we don't know, but what the system does is they say we have to predict risk. so that we'll only let people out of prison who are not a risk to society. And we're going to bend over backwards, particularly after a Las Vegas type incident, to keep people in prison who offer any kind of risk out there. Now, who are we going to get to put some scientific validity on that? Well, let's ask the psychologists to do that. So the FAD is the Forensic Assessment Division. It's a separate unit. The parole board, by the way, is separate from the California Department of Corrections and Rehabilitation. The FAD works for them. It's the Forensic Assessment Division. It's a few psychologists in Sacramento, and we've been negotiating with them. And then it's a whole lot of psychologists out in the field who are hired mainly on a contract basis. Very few of them are on salary. And they go around and they interview prisoners and they do a thorough document review. They get the confidential information. Then they write a very, very long report. And there are several components of the report. There's their history, what it was like to talk to the individual. There's the person's life story. There's their career criminally. That is all the crimes they've been convicted or accused of, what they've been arrested for. Then there's all of their disciplinary proceedings in prison. Then there's all the programs that they've done, and they go through and they list all these things. Then they do psychological tests, and they come up with a diagnosis like antisocial personality disorder. And then they make, and this report, to show you how important the risk is, it's called a comprehensive risk assessment. That's what a CRA is. So the psychological report gets collapsed into a risk assessment. And the risk assessment is going to do things like say, well, there's multiple incidents of violence in the past. There's callousness in the violent incidents. There's disciplinary problems in prison. There's substance abuse related to the violence, and there's an antisocial personality disorder or some such thing. It can be narcissistic. It can be anything that has a negative stigma. And they write this report, and then they say in getting to the diagnosis, and they say this person is a minimum, medium, or maximum risk. Now I'm going to build on something that Keith said about get representation. That psychological report looks very convincing. It's built on a lot of false information, or it's built on information they're not giving us, the people who are representing the prisoner, or the prisoner, for instance, the confidential file. So it has to be picked apart. Now, if on the psychological report, which is called the Comprehensive Risk Assessment, it says this person has an antisocial personality disorder and they're a medium risk or a maximum risk, get a psychologist or a psychiatrist to do an individual report. I don't think the prisoners are entitled to it in the sense it won't be paid for.
That's for sure. They definitely won't be.
So the family has to pay for it, but we have to pick apart this report, and that's what I've been doing. So, and I've been recruiting people, psychologists, to do 1 or 2 parole evaluations. And what happens is we get whatever records we get, and if there's representation, if there's a lawyer, we get the lawyer to turn over all the paperwork we have. We get the comprehensive risk assessment, and then we also get from the prisoner all of the risk assessments, because every time they've been up to the parole board, they've got a risk assessment. So we get all of those, and we look through and read them and see what they're doing. Most of them are copying the last comprehensive risk assessment. They just bring it forward. It's probably on their computer, and they just and fill in a few recent data. And then what I do is I go through and I debunk it. Kalima, is it all right if I mention something in your background? And Kalima won after, what, 21 or 22 appearances, and the last several times got vetoed by the governor. Schwarzenegger, I think, once, and Jerry Brown once or twice. And then Jerry Brown finally, under pressure, approved it. After the parole board had approved it. And usually the parole board denies parole. But I've been working with several prisoners where the parole board grants parole and then the governor vetoes it, and then we've got a whole other kind of problem, which I turn over to Keith and other attorneys. So on Kalima's record is substance abuse and crimes of conviction involved with substances. And now he is in remission in an institutional setting. All right, what does that mean? That's code. That means Kalima is a heinous criminal who uses substances, and the only reason he's not using substances right now is because we've got him locked up. So I have to say, hold on a second. Now my understanding, first of all, is you can use substances in prison. So being locked up is not the reason he's not using substances. Second of all, in Kalima's case, he did use substances in prison the first several years. Then he totally transformed himself in 1981 or 1982, became clean and sober, became a imam in his religious group, a Muslim group, and counseled younger prisoners on recovery, on staying clean and sober. So I wrote in my letter, I'm saying, wait a second, if you've got somebody who's running drugs in prison and doing drugs themselves the whole time they're in prison, you're going to say he has a substance abuse problem. And you're saying Kalima has a substance abuse problem. Are those two not different? That he has been clean and sober for what, 25, 35 years. And he's been counseling other people in recovery. So your category of substance abuse in remission because of an institutional setting is totally bunk. And I didn't say it quite that way in the report, but I said, this does not make any sense. All right, another one came to my attention recently, 115s. We have to, if we're doing a psychological psychiatric report, we have to really, really know the disciplinary history. So 115s are very important. A colleague just told me about a prisoner he's doing a parole report for. It has involved in a riot many, many years ago. So my reaction, riot, what is that? We have to find out what happened. So we have to ask the prisoner, what are you talking about? You were involved in a riot in 1990 something. What is that? And the prisoner says, I got jumped and I fought back. And the guards came in and there was a bunch of people fighting and they said we were rioting. I said, okay, tell me more about that. Tell me exactly what happened and what were your involvement. I stuck that in my, this one isn't mine, but we have to stick that in our report. And here's what we're doing. Back to the two stories. There's this one story that this is a heinous criminal who, of course, if there's a riot, he would be an instigator of it. And he needs to be in SHU and he can't be let out. And the other story is this is a decent human being just like you or me, but because of fortune he's in prison, did some stupid things when he was young or whatever, did substances, and changed. And the riot is understandable as something that he had a predicament he was in. That is, he had to fight. You can't just stand there if you get attacked. And so we give it another spin. We tell another story about someone who is far from a heinous criminal. And we work that through so that, as Keith was saying, everything in their files is on the table. So we have to give it a different story, put it into a different context. Now, the other thing, do you want me to go on or do you want to ask the questions?
Let me see. Well, no, I think you're on a roll. Keep going.
All right, so now we get to the SHU. All right, first of all, I think I disagree with you a little, Keith, and that is that I think our criminal justice system is based on the informant system. I have done a couple of dozen innocence cases, people who spent 25 or 30 years. They were literally innocent. Some had a criminal background, some didn't. But we had evidence. The liability part of their eventual civil lawsuit was the DA, and the DAs are immune in this kind of a situation, but the DA and the sheriffs put someone in a cell next to them who was a real sleaze, and had that person testify that they confessed to them doing the crime. And in payment for that, they got a lighter sentence. The person had informed on him. So I'm talking to this prisoner who, a lot of prisoners say, I didn't do anything. And some of them are lying and some of them telling. But there's a large subgroup of prisoners who were caught up in the informant system. They got false testimony against them. The DA says, look, first of all, they don't have an attorney at this point. They might be meeting a PD for the first time. We have enough on you to send you up for 75 to life. Now, if you'll play ball with us and either roll over on someone else or plead to this or whatever, we'll give you 10 years. Well, compared to 75 to life, 10 years looks good. So there's an awful lot of people that this happens to. Same is true in the SHU. Gang validation is a tricky process. Bato told me this many years ago. Bato told me that mainly white officers see these Latino guys, you know, slapping five and, you know, with tattoos and stuff. They don't know what's going on. They say, well, we think that guy's related to the gang, so the guy that's hanging out with them must be related to the gang too. We're going to put him in SHU. They put him in the SHU. Now, I'm not saying everybody in the SHU is innocent, but a lot of them are. So they put him in the SHU. The next thing that happens is the guy says, I don't belong here. I'm not affiliated. And they say, well, we don't care. You need to debrief. And that means you need to give us 3 people. So now he's stuck, the same as the guy that had the choice between the 10 years and 75 years. An awful lot of people have that story. I don't know who's telling me the truth and who's not, but an awful lot of people tell me a story like that. Now comes the thing Carol mentioned, which is the 6-year I don't know whether it was revalidation or re-SHU assignment.
Active, inactive review.
Inactive review. All right. When I collect data, you know, I'm talking to people who are fairly straight shooters. I mean, the most honest people I talk to are the prisoners. And when I talk to staff, I have to take it with a grain of salt. 100% of prisoners tell me that that 6-year review is totally bunk. And like Danny was saying, they'll find things like there's evidently, and I haven't studied this, some symbols on the Mexican flag that guys like to make tattoos or put on letters and stuff like, and the system thinks it's gang stuff. So they find that and they put that, or the card they've signed, or a picture of somebody that they're seeing.
The language, Nahuatl,
Uh-huh.
that's banned. They're bastards for doing that.
Right.
That's cultural genocide as far as I'm concerned.
Well, 100% of prisoners tell me that their 6-year review was totally bunk, that they were falsely continued in SHU. And this is before the Ashker case, so that happened over and over again, and they spent 30, 40 years in the SHU. They hadn't done anything, no 115s, and it was alleged that they were still gang affiliated. Now, I don't know the absolute truth, but there's a lot of slippage, and I really question that the guys that were the named plaintiffs in our case, in the Ashker case, had been active in any kind of gang activity for decades. I mean, some of them admit that as a youngster they'd been involved in some bad stuff, but they're 20, 30 years clean, and they're getting 6-year revalidations. It's bunk. And so what we need to do is, that is evidence against them for parole. The fact that they were continued in SHU means that they weren't upstanding citizens. So we have to go back and look at that and give another explanation. I was fascinated by the way Keith explained it, because I think it's absolutely true that you have to be honest about all this. So the person that gets charged with a riot for defending himself in a fight that becomes a group fight has to say, well, that's what happened. And we have to go back incident by incident and explain it as part of a different story, as someone really trying. So the issue of not enough programs. Well, I was in SHU. Well, we have programs in SHU. We give you manuals. Well, you know, one of the symptoms I report about being in the SHU is you can't concentrate. So it's amazing that you were able to study in the SHU. And I find lots of people who are able to study in the SHU, but they're doing it against huge disadvantage because their memory is impaired, they're not able to concentrate fully. So a lot of people tell me, I can't do that manual. I was in school, I never did well in school with a teacher and tutors. I can't sit in this isolation cell and then accomplish a course by manual. So I put that in my report. I say, yes, it's true that they didn't do a college course in the SHU. They were not able to, and there was nothing else available to them. And so repeatedly, you have to kind of tell the story that this is, you know, a guy, and he got caught up in stuff, and that was 40 years ago. And since then, he's been suffering greatly, hasn't done anything particularly awful. And you've got no 115s for 20 years except the hunger strike. So that's the next thing we have to, it's on those comprehensive risk assessments. So I take the hunger strike, and Carol has helped me work on this one, that there was this case where a prisoner sued, that, and I think the result was they cannot be punished for taking part in the hunger strike because it's a First Amendment right. So I put in my report, which is a psychiatric report, look, they're in the SHU. They've filed grievances. They've done every single thing they possibly could to stand up for their rights. And at every turn, they've been disrespected, and I watch my language in saying that. I don't accuse staff or guards of anything, but they have not been able to have their grievances redressed in any other way. So as a last desperate act, they do a hunger strike. It's peaceful. They're extremely articulate. The demands they made actually were extremely reasonable, and actually the department eventually agreed to all of them when they settled the Ashker case. So how can you hold that against them? But there's another side to it, and that is, I say to the parole board, you are trying to decide whether this individual will make a good citizen in the community after they're released. What qualities do we want in a good citizen? One is that they remain sane in an extremely stressful situation that tends to make people insane. Second of all, they have a moral system that they abide by, and they're very principled. So for instance, the refusal to debrief, I actually explain it as part of that. That the refusal to debrief, it's not that they're still affiliated with the gangs, which is what the nasty story is. They just never gave up their gang affiliation. It's that they have a sense of principles and they're adhering to it. And that's why they didn't debrief. And you want them to be able to express themselves and in a peaceful and social way accomplish goals. The hunger strike. They did all that. They showed you they can do all that, and then you agreed to their demands. So that's actually a plus. That's a pro-social. So what I'm doing over and over again is moving people from this heinous criminal who needs incorrigible and needs to stay in the SHU forever to this is a really decent human being with a lot of admirable traits and actually would do very well out here in the community. And so if there's anything in the comprehensive risk assessment that would bear poorly on the person getting parole, I believe, and I think we need to do some organizing, we need to find volunteer psychologists and psychiatrists because this is not supported financially. If they have a right, when they have a right to a representation, is that paid for?
Yeah.
The state pays, yeah, $400 per case for a lawyer.
Well, but there's no such thing for a psychologist or psychiatrist to rebut the
no.
CRA. So I think if there's anything in the CRA that is at all negative and bodes poorly for parole, I think an independent psychological or psychiatric evaluation has to be done. Now, we have to educate the psychologist or the psychiatrist. I can't do all these reports. people don't understand about hunger strikes and SHU and the damage of SHU and that kind of thing. We have to educate people about that. That's actually why I do the writing I do. That's right, I wrote a book on solitary. And that's the reason, is to make something that goes on in a dark, secret place, the SHU, known out in society, so we can, have a discussion about, do we really think people ought to undergo successive cell extractions and be sprayed with pepper spray for something they've done alone in a cell? What sense does that make out here in society? And do we really want our representatives, the correction officers, to be treating people like that? And the more we make that public, well, in my little corner of making things public, I try to train psychologists and psychiatrists to do parole evaluations. Or the other thing, by the way, which is extremely comparable, is, the Miller v. Alabama Supreme Court case, which was about juveniles across the board being given life without parole. And Miller v. Alabama, it was decided that can't happen. We have thousands of people who were tried as juveniles and given life without parole. They have to be resentenced. A resentencing report is similar to a parole report. And in the same way, they have to be presented as a decent human being that got caught up in some bad stuff, is not defensive about it. I like the way you formulated that, Keith, that we have to honestly address each of the incidents, not be defensive about it, be honest in the response, but make it part of a different narrative. And the narrative is, this is a decent person, got caught up in things, did stupid things when they were a kid, whatever, and here they are now as this rather admirable human being. And then point out all the strengths and community support, and so all of that.
So I'm wondering if there's a little bit of a tension between, you're talking about picking a report apart, which sounds a bit like, the defensiveness.
Yeah, I want to talk about that.
Yeah.
And because if I were to hire a psychologist, and we've done this in the past, used to do it fairly often. We get a negative report from the parole board's psychologist. We hire our own psychologist to do an evaluation, a full evaluation, and then present that to the board. The commissioners will, at worst, they'll attack our report and its author. At best, they'll completely ignore it in a lot of cases. And when we get to court, we would do this to set up a challenge in court, or at least incorporate it into a court challenge. The court will say, well, the parole board doesn't have to give that anyway if they don't want to. We're not going to require them to give it away. So what I would say to that is two things. One, I think especially in the resentencing context for young people, that kind of evaluation that you're talking about is really, really valuable, and is treated more as an objective assessment than the one that I may get for the parole hearing specifically. Because, so what I do now is, rather than hire someone to write a report, I may hire someone to provide therapy, to provide counseling, so that they're saying, there was some concerns that there was a deficit in this area. I've spent the last 6 months working with this person on this area. Here's the work we've done. Here's what he's gained from that. That report then becomes more documentation of the programming the person has continued to do. Again, it's more like an objective, here's more work that he's done to address those issues. It's not, this is a critique of our report. It's, okay, this is more information that's relevant and seems reliable. And so if I'm going to use it to help them understand the client better, or to help them recognize the client has tried to fill whatever gap their psychologist identified, it's better received by the parole board, in my experience. That's how I use it now.
Well, let me just respond to that. First of all, on the issue of defensiveness, it's one thing for a prisoner to say, I didn't do it, or that's not a valid charge or something. Yeah. And another thing for a hired professional who's doing a professional assessment to say that. So for instance, the riot example, or the 115 for the hunger strike. As an outside psychiatrist, I think I can have a reasonable discussion with the parole board. They're experts, they're professionals in their correctional status. I'm a professional in my status. And for me to say to them, you know, when you're looking at whether someone is going to do well after they're released or get into more trouble with substances, violence, and crime, I actually would like to respectfully disagree with you about their participation in the hunger strike being an evidence, and this is literally what they say, evidence of continuing antisocial traits.
Yeah, right.
All right, I'm an expert on antisocial
Right.
personality disorder, as is the person who wrote the FAD report. And I'm basically saying I want to respectfully disagree with you. Here's the DSM description of antisocial personality disorder. Here's what this person, the FAD psychologist, said about participation in the hunger strike, and here's why I, another professional giving a contrary opinion, don't think that's valid. Now, another point where I'm argumentative professionally is about personality disorder being a lifetime, unchanging characterization, so that someone who has antisocial personality disorder, first of all, has the same personality disorder their whole life. I don't believe that, and there's a valid debate within psychiatry and psychology about that. And second of all, is not amenable to treatment.
Right.
Those are the assumptions about antisocial personality disorder. They're wrong. Now, in some individuals, they're right, and the reason is because the individual isn't changing and isn't amenable to growthful experiences. That's true, there are such people. But actually, that's few and far between. Most people I meet who legitimately could have been called antisocial personality disorder earlier in their life because they had, one of the criteria is you have to have conduct disorders or oppositional behavior before the age of 14. Sure enough, that's in the history. Then they have to have had activities like crimes where they have victims where they didn't really care about the victim's experience. Well, that's true. When they were 16 and they did such and such, yeah, I don't think that shows a lot of empathy for the victim. But they've spent 30 years discipline-free in prison, and they've turned into this interesting person I'm meeting who, by character traits, empathy, caring, discipline to delay gratification and plan for the future, all of which are contrary to the antisocial personality disorder diagnosis, they do not fit the diagnosis, therefore the diagnosis is wrong. Now, I do that over and over again and basically debunk the antisocial. If the prisoner did it, it would be defensive.
Yeah,
when I'm
absolutely.
doing it, I'm joining a debate in mental health, and I think that's valid, and I find that they listen.
I agree.
In Kalima's case, I went to the head of the FAD, who I have an ongoing adversarial but friendly exchange with, and I said to him, I said exactly what I just said here. Are you telling me you're giving him points for risk assessment, that he was either a medium or a high risk based on one factor being substance abuse, and you're telling me that he's the same as someone who's still using drugs and dealing drugs in prison? They both have substance abuse, so they both have the same mark against them? Or is there something qualitatively different when he becomes clean and sober by his own doing in 1981? And the guy agreed with me. And he said, we're going to revise that criterion.
I think what's really important about what you're doing is you're educating them, right? And they're much more open to being educated than to being told or forced or litigated. And you present it in a way that says, here's a different opinion, consider this different context for the information you have. That I definitely see that being successful. Absolutely.
Let's see.
You have a question back there,
Okay.
Carol.
All right, yes, Joseph.
My question is, you adhere to the DMS-4, right?
You know, in my writing, I'm very critical of the DSM, but I don't think the parole board is the proper place to have that debate. So yes, I use the DSM-4 or the DSM-5.
Right. So my question is, you people are not clairvoyant, are you?
He might be, but
That's right. But see, we're working with real people who are doing real things. We know how the parole board behaves. We know what kind of argument they'll listen to, and I agree, it's mainly education that I'm doing when I challenge them like that. So in the antisocial personality disorder, there's a technical problem. The technical problem is that the way the thing is written, there's no timeline. They don't say they were this way when they were 16 and they're this way now. They say they're this way sometime in their life, callous, uncaring about their victims,
yeah.
Okay, they were. And therefore there's something about them now that we can say because of that.
Right.
And I'm saying, oh no, that's not correct. That in fact, in clinical experience, what we find is a lot of people, because of the immaturity of the juvenile mind, because people grow, because, for instance, most crimes and most substance abuse happens in a huge rise in frequency between the age of about 16 and the age of about 25. That's where most of the stuff happens. And then people get caught up in prison, and the ones who get into the prison life get into further trouble because I think prison damages them, particularly solitary confinement. But most people get over it. Most substance abusers, you know, there's millions of substance abusers out there. They're not all caught, but millions of them. Some of them go on to corporate and political jobs. They stop doing it in college or in grad school or when they're working or whatever, or when they have a family. And so it's not correct to assume that because someone committed a crime that demonstrates callousness at 16, that they have a personality disorder that's life-lasting and unchanging, or that they would not be amenable to treatment. By the way, Keith, I like the idea of having someone treat, if you can range that in prison, and address something that parole board raised. Yes, I'm all for addressing everything the parole board raised in the previous hearings. That's really important, and that the prisoners show that they're doing that. So you have not explained yet what you were thinking when you did this crime. Prisoners should think about that. These people, you know, they happen to be heavily police-oriented, but when they raise a question like that, if I were the prisoner, I'd say, oh, that's interesting, so you didn't like my explanation. Maybe it's not deep enough. Let me think about that. And you want to show the parole board next time that you've done that, and you've advanced your self-understanding and your explanation of why you would not be at risk of doing that again.
And that's sometimes what they call insight, right?
That's insight. That's their insight.
Become a very big topic. So let's see. I'm going to just mention what we have left for the rest of the time. I want Pam to come up and talk about what our committee has been doing, and to kind of show, explain to you the materials that we have over there, so you know what you're walking away with. And but we also then want to go back to Terry, just sort of to say, okay, that's sort of the end of our parole presentation. But Terry, because of all his interviews, has a lot of insight into what SHU has done for people, to prisoners, and we thought it would be helpful for him to spend a few minutes talking to you about your loved ones or people that you know who are who were in SHU, who were harmed by that experience, and how that manifests itself, what you can anticipate, what you might have already experienced. We have some material from his report condensed that Sharon's put together about that, and if you could maybe talk about that. And then and Terry also has just written a book that's over there for sale, and he'll be there to sell and sign them at the very end. So we have about half an hour left. We actually have the room till about 5:30, but we can't stay beyond that. So I want to see if there's any other topic or issue for any of these our speakers that.
Just to ask Terry what the SHU syndrome is. shoe syndrome.
Oh, well, that's kind of what you're going to get into.
Right, but let
in a
me
minute,
make a
but okay.
point about it, because Carol's
Sure.
going to have me get into it in a little while, but let me make a point about it. I want to flip the understanding of experience in SHU. Since we won, we settled the Ashker case, but I think it was a huge victory. It isn't right to put people in a box and leave them there for decades. That's what the state of California and the courts decided. Now, there's a group of people who that was done to, and they survived it more or less well. A lot of people killed themselves, a lot of people went crazy, a lot of people debriefed, and according to the rest of the prisoners, and I wouldn't say this to the parole board, they snitched. And now they're on the special needs yard, and they're a problem for the state. There's a lot of violence on the special needs yard. The gangs are on the special needs yards. So for someone who have done their time in an extremely unfortunate situation, which has since been decided is overly harsh, to have survived and educated themselves and come out sane and make and keep contact with loved ones, which is another big issue for the parole board, is rather remarkable. The way Danny survived, or Steve, or people who've been in SHU for a long time, survived and came out as remarkable and admirable people, should be a sign for the parole board, and we have to, it's not, the fact that they've been in SHU is not over on the side of them being a heinous criminal and incorrigible. We want to reverse that story. It's on the side of them having remarkable strength of character, which is just what we want in someone who's going to come out and be in our society.
You know,
If
the
I
other
may,
thing, oh, go
if I
ahead.
may put piggyback off of that, I think it's also important to understand that, you know, the transformation that occurred in Pelican Bay SHU with me and a lot of other people is not because of Pelican Bay SHU. It's in spite of it, right? A lot of us, you know, at least I went in there understanding that this place is literally designed to break me, right? So me and other people figured out ways how to overcome that. And whether it was through books, whether it's through, you know, conversations, writing letters, just getting to know ourselves better, it was not because and designed by the SHU. It's done in spite of that.
You know, and I would say about a lot of my conversations with people at Pelican Bay, and just talking about what it's like to live in a pod of 8 people, so many people talked about how, well, you're quiet because you're respectful of the others in the other cells near you, or they're sharing because, or people send magazines around so everybody can read it, or they take the various things that, foods that they had and they put together, make some kind of cake on someone's birthday, or, you know, there's just ways in which the pods themselves create this little social environment, which there's a lot of, you know, kind of support for. And maybe every pod's not like that, but they're trying to, you know, they're prisoners, they have each other, and it's across racial lines, and it's, and group lines, and you know, that's part of the solidarity that developed, and with the agreement to end hostilities, people were all in a similar boat, and they recognized that about the humanity of each other. So to me, there's a story of SHU that actually, for probably many people, it can be told in that kind of a favorable way. So yeah, they might not have been programming, but they're having a life experience with other people, in which they were showing and developing their own humanity. Now, some people are just there by themselves and getting kind of messed up. That's true. But I think a lot of people are having that other kind of social, you know, social, like the man that you talk about who mentored you. You had, that was powerful for you. He was doing something powerful for you. He is someone who, you know, might come up for parole, you know, and he can, it can be pointed to as something that he did, even while he was in SHU. He was helping others. So, and I know we see that a lot with, you know, someone falls down, you're calling out, hey, so-and-so fell down, we need help here. I mean, there's a lot of camaraderie and friendships that happen too. So I don't know, I haven't heard anybody ever talk about, trying to find ways to talk about the SHU experience that can reflect positively on who you are today, you know? So anyway, I just want to toss that one out.
Carol, I didn't get my question asked. I asked about the SHU syndrome, the damage done to the people that, you know, don't get positive, don't get all this other stuff, the damage, the done to the thousands of people that went through there. And they're permanently fucked up for life, right?
They may be, but
Well,
but
what is the
Danny's
SHU syndrome? What is
Danny's
the
sitting
syndrome?
right here.
What is the deal?
Danny's sitting right here, and I don't think he's
He's
fucked
an
up for
exception.
life.
He made it.
Well, and that is admirable and pro-social.
I'm not
That's
saying it's
my
not.
point.
I'm talking about people
let me
that
just
didn't
say,
make it.
all right.
What's happening with the people that didn't make it?
Well, let me just say a little about first of all, suicide. A lot of people don't make it because they're dead. There is a stunning statistic across the country. On average, 50% of successful suicides in prison. Now, suicides in prison are at least twice as frequent as in the general population outside of prison. But 50% of the successful suicides happen among the 4 or 6 or 8% of people who are in SHU or in isolation. There's other forms of isolation. That is a stunning statistic. Actually, in California, it's 60%. 60% of successful suicides in the CDCR happen among people who are in solitary confinement of one kind or another, ADSEG, SHU. So that's the awful worst damage. There's a set of symptoms that are we used to call the SHU syndrome. We haven't been calling it that for years, but that almost everybody has. I've never met anybody who didn't have a certain number of these things. High anxiety, panic may be part of it. Thinking distortions, some problems having logical thought, paranoia being a frequent variety of it. Difficulty concentrating, difficulty with memory, repetitive compulsive acts, cleaning cell, pacing, whatever, counting lines, some people count the bricks on the wall or something, despair and severe, depressed mood and that kind of thing. These are symptoms in relatively stable people. This is everybody, has some combination of these things. People with mental illness, and this includes people who've never had an episode of mental illness yet, because remember, people go to prison when they're 16 or 18. Schizophrenia, usually the first psychotic break occurs in the late teens or early 20s. So we have a large number of people who are going to be diagnosed schizophrenic later. They go to prison, they get sent to SHU, often because their mental illness keeps them from following the rules, or they get victimized. And they have a psychotic episode in SHU. So now, it's sort of, unless you spend some time doing a thorough diagnostic assessment, you don't realize this is someone who's going to suffer from schizophrenia, and the awful conditions in SHU are causing that first breakdown and making it worse. So, and depression will be worse, and that's where the suicide comes in. Bipolar, just think of someone who's manic. You all know people who are manic. They like to move around, they're very energetic, they talk a lot, and if they talk a lot with a guard, they're gonna get a 115. They get angry, so people with bipolar disorder don't do well in SHU. And what it does is that it exacerbates their mental illness. It makes it much worse. So that's what we used to call the SHU syndrome. We have other names for it now.
One of the questions is, though, is having gone through that experience, does that, of the long-term SHU or having those collection of symptoms and whatnot, does that make someone a high risk or a medium risk or a low risk? I mean, a lot of times people come out, the people that we've talked to, they come out and they don't, from a long-term SHU, and now they're in the community, and they don't want to go outdoors. They don't want to go to a store because there's too many people around. They're still suffering some of that anxiety and whatnot. And I don't know, what I've seen is they may end up going self-medicating with drugs or alcohol, and that seems to be the main negative risk. But other than that, I've sort of been seeing people kind of just trying to live a quiet, normal life. So anyway, I don't know how that fits into any of this.
Well, that actually is complicated, and we need to talk about it first.
Yeah.
Having a mental health jacket is not going to do anybody any good. So where I could argue this person has post-traumatic stress disorder from previous trauma, and that's why they did something they did, I would think that's going to help them. that might be exactly what the parole board says, yeah, and we don't want to let them out of here if they're going to be like that. So mental illness is a little bit of a ringer in all of this, and what's consistent with the Ashker case is that all of the guys in the SHU refused mental health help. And I think the main problem I saw among the guys was severe depression. And they just said, of course I'm depressed. I'm in this torture chamber, I'm depressed. I'm not going to talk to their shrink. First of all, I don't trust them. And second of all, it's going to hurt me in the future if I do ever get to the parole board. So it's a little bit complicated.
That is a well shared idea, and it's not really true. It used to be more than it is now. I'll put it that way. That instead the parole board, rather than saying, because you have a history of mental illness and mental instability in the institution, because here you are on triple CMS or EOP, one of the mental health programs within the prison, that raises concern and elevates your risk. Instead, what they're doing is they're saying, the fact that you reached out for help shows that you're taking care of yourself. Shows you're doing something you didn't do when you were 16 or 18 or 20, and it actually works in people's favor more than it ever did before. But it takes a while because you got decades of a culture where that's not the case, right? It's the stigma, it's the no, I don't want that label, and I don't want to be a JCAT, whatever they call it. I don't want to be that because that means they'll think I'm crazy and unstable.
The challenge with that, having worked in the system as a psychiatrist, is that the continuity of care is highly interrupted.
Right, and it's also a part of the release planning to identify the resources available in the community. Where is he going to go?
Right.
Where will he get the continued service? Now,
Realistic is that plan?
right, in some places it's just not existent. Not beyond they call it the parole outpatient clinic, which is the first place that people will stop. Same place, the parole office, where there'll be an assessment to decide whether someone needs continued treatment, but what they actually get is variable and inconsistent. But so to the extent families and other supporters can identify those resources and have a letter, we will accept him in this outpatient program or whatever it happens to be, that helps to complete the picture.
If I may real quick, one of the things that, when I came home, right, my focus was just to have something to do, have structure in my life, and that's what community college gave me, right? It allowed me to create a program and kind of, have something to do every day. And same thing as in prison, right? Like I always needed to have a structured program. I wake up, do workout, read, watch TV, do this. And when I came home, going back to the point that Keith made about not seeking that help, right? When I came home, the first 2 years I was in community college, like my very first semester, I got paired with somebody who, although not formally incarcerated or not part of that system, but grew up in a community where he's seen drug violence and all these things. He became my mentor, and he would always tell me, like, dude, you need to go to DSP, Disabled Student Program. And I held down to that belief for a very long time. Like, nah, I don't need that shit. I don't need it. I'm good. Like, as long as I got, I got my little job, I'm doing my homework, I'm good, And then it wasn't until I came to Berkeley, and in 2013, when I got involved with the hunger strike, and I started doing the interviews.
The media interviews?
Yeah, that's when I realized, oh shit, I need help. I need help. Because like, I would do these interviews, and then like for the rest of the day or next 2 days, I couldn't do nothing. Paralyzed, just wanted to just depressed or just sad. Yeah.
So that's what I'm saying about the external. We need to be very careful that we don't that all of us, the community, are open to success in the exterior version. We just look at the outside and say, oh, okay, the person's doing great, but we need to also be very conscientious about the inner world that people have lived in isolation and solitude, all alone, and that has been so protected. And once they come out, you've got to break through that.
Right.
Pam Griffin is she is an amazing person. She's on our committee. She's an attorney whose husband was a long-term SHU prisoner, gang validated, and she litigated his case. So she brings, everything to the picture. And
I think, Carol, you already covered some of the background, which is explaining what Prison Hunger Strike Solidarity Coalition is, also how our committee got formed. When we started hearing these reports of prisoners running in the parole hearings, being asked to debrief, being penalized for hunger strikes, being penalized for the lack of programming in all the years in SHU. And kind of another issue that has come up along the way is the use of confidential information in the hearings. So after we formed, what we originally did was we started collecting materials. And a lot of prisoners were very generous in providing transcripts and their psych reports, so we could kind of build something that we could see what was happening in the parole hearings. And then together we started putting together our thoughts and arguments against these practices and why it was wrong for the board to rely on them under their own standards. And that ended up with an outline that we have called Rethinking Parole, which is in the materials over there. And thankfully for you, minus the 30 or so pages of footnotes that we added to support our arguments. If anybody wants the footnotes, there's an address on there that you can write to and we'll send you the report. Then we got an opportunity to meet with Robert Barton, who was the Inspector General of the state. For those of you who don't know, the job of the Inspector General is basically to audit and do investigations of what the Department of Corrections does in the state, including the parole board. So we met with him, and interestingly enough, he's now been appointed as a parole commissioner recently. So we had a good meeting, even though he pretty much chatted our ears off. But he did send our materials over to Jennifer Schaefer, who's the chief executive of the board, and basically cleared the way for us to meet with her. So after several delays, we finally met with her in January, I think it was, of this year. And she was very gracious. She had 2 lawyers with her, always a wise thing to do. And she seemed a little skeptical about our claims, and as they always do, and Carol predicted they would do, they say, give us some specific examples. So we, over the next couple months, sent them about 20 examples of transcripts that we wanted them to take a look at. Now we've followed up 2 or 3 times, not much has come of it, so I think about now is time for us to follow up and maybe apply some pressure for some real discussion with them about this. Also, Terry was kind enough to give us some assistance in putting together a memo on how prisoners and their families and supporters can counter these board psych reports. So we also have that memo. It's a part of LSPC's packet of parole materials that they've put together, which includes some things from Keith's organization on common law. It also includes that memo that we put together. And then we also knew that many parole attorneys don't really know that much about the SHU experience, what happened there, about debriefing, about all of these things. And so Carol put together a webinar for parole attorneys and reached out to a lot of the appointed attorneys and generally parole attorneys around the state. And that one is still online for anybody who wants to see it anytime. And I think Keith and Danny were both part of that panel for that. Then we said, okay, we need to reach out to family members and supporters too. So we had an event in Southern California in July, and now we're having this one in the Bay Area. And one other area we're starting to focus on is the parole commissioners. As you know, the governor appoints the commissioners, then they have to be approved or confirmed by the Senate Rules Committee. And so we're kind of starting to work with some other groups that are lobbying the Rules Committee on certain commissioners that they are not liking. some of these guys are really rotten in these parole hearings, as you know. And so we're starting to work on that. One thing we did recently was we shared some of our CRAs, or the psych reports, with the Life Support Alliance, who is working on a project to challenge the board psychologists in their evaluations.
Then we met with Terry went up to Sacramento and met with the head guy, FAD, with Virginia.
Oh, right, I left that out,
Yeah.
right. Terry and Virginia of our group also went up and had a meeting with the director of the FAD, the psychologist group there. And one area you guys are focusing on is the use of confidential information, I think.
Yes, but I think Keith spelled out what they told us, and it's new. Didn't
Oh,
she
right.
tell us that in our meeting?
Right.
That the prisoner and the attorney can get that, I forget the number of it, but the list of things on the
the list,
confidential
yeah.
file. Because we were getting a lot of reports where they would say, we're gonna deny parole, or the psychologist in the risk assessment would say, confidential information, or they wouldn't even say it, but confidential information says such and such. And we say, what confidential? We don't know anything about this.
Mhm.
And so we couldn't rebut it. So
And
they made that
actually,
correction.
yeah, Jennifer Schaefer told us about that in our meeting with her, that their attorney staff was gonna start reviewing the confidential information and writing up summaries themselves. And I was thinking to myself, this could be great, because our past experience is that if you have the original confidential memorandum and you have the 1030, they don't match, they're misrepresented, the dates are misrepresented. So if the board is actually looking at them, we could end up with something that actually reflects what the original confidential memo is. It won't tell you if the original informant was lying, but at least it knows, that it's accurately reflected in the documentation. And just to go over briefly what the materials that we do have over there, I know there are a bunch of materials from PHSS that they prepared before their last newsletter, the various items that they have there. What we have is the parole packet from LSPC. We have the Rethinking Parole outline. We have a condensed version that one of our members, Sharon, has put together of Terry's expert report that he did for Ashker. The original report is quite lengthy, and Sharon kind of condensed it down to a nutshell that the rest of us can enjoy and read. And that's over there, along with some letters that she received from prisoners commenting specifically on Terry's report. So, we also threw in a list of parole hearing tips from Life Support Alliance that was in their last newsletter in September, and a brief description of those 4 questions, which I think somebody may have sent around earlier. Okay.
I want to make one kind of update about been a lot of talk about the comprehensive risk assessments, these CRAs. We have a class action against the board about these risk assessments, and we reached a settlement that required them to establish an appeals process, a formal way to challenge errors in these reports. And they drafted regulations to implement that settlement that we didn't like, nobody liked. We objected to those, and we asked the court, the federal court, to reject them also. And we just learned yesterday afternoon the court rejected the regulations, or at least it requiring them to go back and rewrite the part that spelled out the kinds of errors that you could challenge. Because they wanted to, I mean, the biggest, most egregious thing was they wanted to say people could challenge factual errors in the reports, but factual errors would not include the psychologist misquoting the person's statements. So you said this was an accident, you said it was the victim's fault in the report, and you talked to the client. Well, I didn't say that, it's not what I said. I said it was something different. The board wanted to define that as not an error. The psychologists got that completely wrong. They wanted to say that's not an error. And so the court applied logic and like common sense and actually cited the dictionary definition of like, you know, like factual and, you know, like the basic stuff, but sent them back to the drawing board. So we're going to be reworking those regulations over the next couple months, I think.
That's good news.
Yeah. Yeah,
Can I make one more comment?
Yes.
I'm sorry to
That's all right.
rip. You know, really, what I said about there's two stories, two narratives. One is that this is a heinous criminal who should be in SHU and they're incorrigible. The other is this is a decent person with lots of admirable qualities. I make that distinction in my psychiatric report. But there's a file that goes to the parole board, and the file should be entirely consistent with that. So for instance, for family members to recount what caring things this prisoner did while locked in a SHU cell. The guy you were talking with that helped you, when he comes up for parole, a letter from Danny saying this is what happened to me and this has helped me get out of prison. The entire file is important. So for instance, on the antisocial personality, for all of the letters from family and teachers and preachers and everything, to say this person's not callous, they're entirely caring, they help the youth in the community, etc. That whole package needs to be consistent, supporting the narrative that this is a really quality person that deserves to be out in the community.
Okay. Well, thank you. With that, I think it's a little bit over time. Terry, we wanted to ask you to talk a little bit to family members about what they might expect if their loved one comes home, or even relating to them now as former SHU people. I don't know how we can pull that off. I want to let people go who plan their afternoon and can't stay for that, but also want to give you the chance.
I met an awful lot of people who told me one specific symptom, that after they got out of SHU, they wanted to stay in their room. If they got out and they went to the general population prison, they wanted to stay in their cell. So every chance they have to lock down in their cell, they would do it. And if they went home, they would tend to stay in their room or in their home. And then some things Mariposa mentioned is that they don't want to be in a crowd. They don't want to be with people they don't know. They don't want to be touched by anybody. They have a startle reaction. All of these things are the SHU post-release syndrome. I want to tell you a quick story which is, I think, useful in terms of how to help people. I went to the SATF, which Substance Abuse Treatment Facility down by Corcoran, as part of the Ashker case because some people had been released from SHU and went there, and they were plaintiffs in the case. So I went to see them, and I saw 8 people, and every one of them told me, when I got out of SHU, I had all those symptoms you're talking about. And there was a commander, I don't know, a lieutenant or some ranking CO, who came and first of all put them all in the same corner of the pod, put them all in neighboring cells, and came and talked to them every day and said, look, you just got out of the SHU, I know this is going to be rough on you, I'm coming back every day to talk to you, and I want you to come out of your cell and relate to each other. And these guys had all been up in the SHU, and some of them knew each other, some didn't, but so they started talking to each other. And the lieutenant kept coming back and talking to them, and they all told me that that's what helped them get through it without going crazy. So, you know, a lot of it is to listen to people, not to tell them what they're supposed to be doing, but listen to what their experience is. We should learn what the experience is. I recommend my book for that. And, you know, just understand them, which is what we do with trauma. When people have been traumatized, we let them tell their story. We don't tell them what to do. We listen. And listening is the core of the treatment. And we have to find an opportunity to listen. And that's true of people getting out of the SHU. And if with some understanding where they get to tell their story and what it's like, they gradually feel better and start involving themselves more socially. I think, where's Carol? I think I'll leave it at that. Okay.
Thanks, Terry. That was great.